the COVID-19 issues. Right now, the big focus is obviously on JobKeeper and on the Leasing Code of Conduct. But it's pretty dynamic. We're sort of getting lots of different questions about lots of different issues every couple of days. So what I'm trying to do is spend as much time as possible. We have 45 minutes to go through all of the issues that people are sending through. And if we have time, I obviously kind of give a bit of guidance on particular pieces of law that have come out over the last couple of days. As of today, not much has come out over the last week. What we're seeing is the ATO have obviously given a fair bit of guidance around JobKeeper. So a lot of businesses know what they're doing around that and are pretty clear on what they need to do and are kind of taking action in line with that. What we're also seeing is there's a lot of uncertainty from various types of businesses, sole traders, businesses that haven't been in business for a long period of time, and so on and so forth. So a lot of the questions that we're getting relate to those kind of specific circumstances. So I think where we are now, just generally in terms of Australian business, is 80% of businesses know what they need to do. The remaining what I'm planning on focusing on today, because we've got a lot of questions. That's really, and they're quite specific. So I think all of you listening will hopefully get a fair bit of insight into your own businesses if we can kind of answer some of these questions. So I'm going to jump straight into the questions. Again, remember, if you do have additional questions, post them on Facebook, post them on LinkedIn, and I'll try and get to them at the end. We've got 30 or so questions to start with, but if more questions come up, happy to answer them. So let's start with Ali's question. 5 months left on my commercial lease. I'm currently not getting enough support from the landlord for rent relief and hardly any rent reduction, and even no rent, especially because of the government regulations. We've been closed and we're a food court. There's no point in doing takeaway. So do I have to pay my rent if I'm not operating? And how do I terminate my lease and get out of the shopping centre? So this is an interesting question. You've got 5 months left on the lease. It sounds like your business clearly qualifies for JobKeeper. And so under the Code of Conduct, the Leasing Code of Conduct, which has come out, if your revenue has dropped by 100%, what your landlord should be giving you is a 50% waiver in the rent that you need to pay and a 50% deferral. Now, in your case, the deferral is not going to work because you only have 5 months left on the lease. So what you should be able to get is half of your rent waived, so you don't have to pay it at all over the next 5 months, but you will technically legally need to pay the rest of the other half of the rent. Now, of course, you can try and negotiate. There's no question around whether you can try and negotiate it. You can try and negotiate anything, but it depends very much on the landlord and what they're doing with other tenants and so on and so forth. But in terms of the Code of Conduct, if you qualify for JobKeeper, and it sounds like you will, you should get a 50% waiver on the rent for the last 5 months of the lease, which hopefully should help. Obviously, it doesn't cover the whole amount owing, but it does help you in some ways. The other things for you to think about are, do you have a bank guarantee? If you've got a bank guarantee, often it's for kind of 6 months, so that's worth more than the amount of rent that you still need to pay. It's not really going to make sense to kind of just try and break the lease and not pay, because if they can call on that bank guarantee, then you're in a bit of trouble. Bearing in mind that the Code of Conduct does say that landlords shouldn't be drawing down on bank guarantees. But if a tenant sort of stops paying rent, they're sort of outside of the code anyway. So the reality is, in this sort of situation, again, know what your rights are, but make sure that you kind of negotiate as much as you can with the landlord. And a lot of landlords are, certainly over the last week, we've seen a lot of landlords being much more willing to negotiate than they were previously. Let's get on to Matthew's question. Does the tenant's preferred comparison period determine the rental relief calculation, or can the landlord determine the comparison period? So what Matthew's talking about here is a business that qualifies for JobKeeper, so has had that 30% or more drop in revenue, also qualifies for rent relief under the new leasing code. The interesting thing here is Under the leasing code, there's then a concept of proportionality. So if revenue has decreased by 50%, then 25% waiver, 25% deferral. That's sort of how it's supposed to work. But it doesn't refer to the periods and the BAS calculation that the ATO is using to work out if you qualify for JobKeeper. So what that means in practice is you qualify for JobKeeper and you qualify under the leasing code. You don't then need to be using the same calculations that you use to qualify for JobKeeper to negotiate with the landlord around the amount of waiver and deferral that you should get under the code. So it's an interesting kind of question there, but really what it means is you can probably talk to your landlord and say, okay, I qualify for JobKeeper, and now what I want to do is, negotiate with you in terms of the amount of waiver and deferral that I get on a monthly basis based on my P&L, but based on my profit and loss statement, not my business activity statement revenue. You could certainly do that because the code is just a framework that is kind of meant to be used by landlords and tenants to work out how to structure the waiver and deferral process. So you don't need to get too into the details of it's this quarter against this quarter, it's this month against this month, under business activity statement and GST turnover numbers, which is what the ATO are kind of using. You need to use to qualify for the JobKeeper. It can be much more based on your P&L or any other sort of calculation. Now, if, for instance, you think that things are likely to get quite a lot better for your business over the next little while, what you might say, but you've had maybe a 30%, 40% drop in revenue in March, then what you might want to do is say to the landlord, okay, for the next 6 months, just give me a 15% waiver or a 20% waiver in rent, and don't worry about the deferral if cash flow is not a big issue for you. And what you're sort of, you're basing that on, okay, I think things are going to get better for our business, and I want to bank in the waiver now. I want to negotiate that. I want to sign up to it. I want to get it agreed, and it's done. And then if the business does well, then you're in a better position because you've had that reduction in rent. Obviously, if the business does worse than you expect, then kind of maybe leaving a bit of money on the table. But all of these things can be done within the context of the code, and so it's important to start thinking about how you're going to use this code to best suit your business, and that's the way I'd be thinking of it. Matthew's got another question. Is there any difference to negotiating with tenants who have a license versus a lease? So a license isn't included under the code, whereas a lease is. So if the tenant qualifies for doing less than 50 million turnover, then the code gives a lot of guidance around what you need to do in terms of 50% waiver, 50% deferral, and so on and so forth. If they're a licensee, then they don't have that protection. Doesn't mean that you shouldn't do the right thing and negotiate and structure things in the right way, but certainly you don't have to follow the framework of the code to do that. Okay, another quick one. So I've got a question from Yami. I have already enrolled for JobKeeper payment with 6 employees from MyGov. However, I just realized that one of the employees who is employed since January 2020 is also eligible to get this payment. How can I revise the enrollment with the correct number of eligible employees? You've got to call the ATO. So it's not really necessarily a legal question. What I would do is I'd be getting on the ATO have a lot of guidance on their website around how this all works. Spoken to a lot of clients who've been calling the ATO to get help. They've put on a lot of additional team members. My understanding it's about a 10-minute wait. Just call them and ask them how to do it. So that would be my suggestion there. Moving on. Brett's question. We're in a partnership and purchased a small wine and food tour business in December 2019. We do not have any employees, and one partner works full-time in the business. Due to COVID-19, our partnership income has dropped to 0. We're currently unable to register online for the JobKeeper payment. It doesn't have an option for us, and we also need to request an alternative test to show our fallen turnover, as we were not in business last year. We're still operating the business, but are unable to conduct any tours, etc. How do we nominate one partner to be the eligible business participant? Okay, so again, call the ATO. Clearly, based on this business, sounds like you are going to qualify for JobKeeper. You need to call them. They're very clear on the website that partnerships, for instance, are included, and you have the eligible business participant. You need to just give them a call and work out technically how you do it on their website. It's not so much a legal question; it's more just a practical do it on their website. Or indeed, if you've got an accountant who's helping you with this sort of stuff, and some accountants are, then just get your accountant to do it. In terms of the alternative test, the ATO have said that they are going to provide further guidance on how they're going to look at businesses that haven't been in business for the full year. So they've said they're going to do that. They haven't done it yet. The additional guidance is not out yet. It's not out yet, so there's not that much we can kind of say around that. But the reality is the government, the ATO, have been pretty open about the fact that they're going to try and make sure that as many businesses as possible qualify under these alternative tests. So based on that, a wine touring business that can't operate, I think you're going to be okay and you'll get the payments. Moving on to Michael. So Michael is a gardener, sole trader, have had my business and consequently my ABN for 4 years. Realised in December I was going to nudge over the 75K turnover for the 2020 financial year. So I registered for GST effective from the 1st of January 2020, the last 6 months of the tax year. Okay, so I read somewhere that tax had to be submitted prior to 12th of March. I have a predicted fall in turnover, 30% turnover from 2019 to 2020. Am I eligible for JobKeeper? Okay, so the first thing is, as a sole trader, sole traders are eligible, so you don't have to worry about being an employee. You are eligible as a sole trader. The second issue is how you've been accounting for, whether you've been submitting business activity statements because you've been under that 75,000 turnover benchmark. The ATO has been pretty clear again that if you're a business that's doing under that amount, you will still qualify. So what you need to do again is call them up, just give them a call, and just work out which of the forms you need to fill out and when you need to fill it out, or your accountant needs to do it. You've obviously got an accountant, so your accountant should be able to do this for you. Based on the information you've given me, you will qualify. So you need to kind of get the form sorted out and get it happening. Okay, Peter. Peter, has there been any clarity around what the alternative tests are for companies? Not really. There hasn't been, is the answer to that. We're a startup where revenues are up 500% from last March, yet revenue has dropped by 75% comparing from the first 2 weeks of March to the first 2 weeks of April. We don't know if we qualify and are hesitant to hire back stood down staff until we get some clarity. I agree. This is a significant issue. That there hasn't been that additional guidance yet, and that is the problem, because you need to start making the payments relatively soon. I think it's before the 24th, 25th of April to qualify for the first lot of payments. So this is a significant issue. We're hoping that the ATO will come out with additional guidance in the next couple of days. And if you're on our mailing list, we're obviously emailing everyone as soon as the additional guidance comes out with some commentary around that. But it's an issue. Look, my feeling, for what it's worth, based on the communications from the government, from the ATO, and the fact that, industry associations, so the Australian startup industry has been lobbying pretty heavily on this particular issue, is that this, hopefully, you will qualify. But there just is, unfortunately, right now there's no guarantee. So challenging question and challenging issue for you to deal with there. Okay, Christy has a question. How does JobKeeper work for replaced employees? i.e. in the case where current employee who is in the role crucial for keeping the lights on in the business decides to leave or no longer wants to work the normal hours of the role and can go on job seeker instead, where the business must then replace this employee, can we continue getting JobKeeper for the job/position versus it being for a defined individual? No, so the way it works is anyone getting JobKeeper needs to have been employed on the 1st of March 2020 if they're a full-time or part-time employee. They need to have been employed by the business on that day. Business decides if you've got someone leave, who is kind of saying, I could come into work, but I can't be bothered now because I can get $3,000 for free, you can terminate that person because you're running a business. They're an employee of the business. They're not coming in to perform their duties. So you need to terminate them and hire someone else who will do their duties. If they're terminated, they're not getting $3,000. They're not getting JobKeeper. And that's entirely legitimate. So in that situation, I'd be having a conversation with the person who's not coming in for whatever reason. And if there's a very good reason for it, they're old, or they've got asthma or something like that, okay, fine. That's a discussion for you to have. But if they just feel like chilling out for 6 months and getting $3,000 and think that that's the way this program works, that's not how the program works. Unfortunately, it doesn't help you with the new employee. If it's someone you've employed post the 1st of March 2020, you're not going to get JobKeeper for them. Another question from Christy. For sole traders and or those who are claiming JobKeeper as the startup/owner/director, is there any flexibility around having to pay us the $1,500 per fortnight for the whole of April with the hit on cash flow this causes until JobKeeper gets paid? No, there is no flexibility. You need to make those payments. If you don't make those payments, you cannot claim JobKeeper. I understand that's an issue. It's a cash flow issue for many businesses, but there's no flexibility there. You need to find the cash somewhere. And that's just kind of, that's unfortunately the reality of the program at the moment. Moving on, Susie has a question. Are employers who run their business with no employees eligible for assistance? And if so, which one? Yes, if you've had that 30% drop in turnover and all of the other sort of aspects of JobKeeper are satisfied, then if you're a sole trader or you're running the business through a trust, you qualify. If you look at the ATO website, and I'll stick this in I'll just comment on this now. Just attach the link, which refers to sole traders and others, directors of companies, and so on and so forth. Very clearly states that you're eligible, and it explains how to go about applying for JobKeeper. So have a read of that link. Okay, Mona, what is the eligibility for me as an employer and Kiwi to get JobKeeper for myself if my business has been impacted and I don't give myself a wage, so on and so forth? So that's the first question. So if you're a Kiwi, you qualify. So it's Australians and Kiwis and a couple of other subclass visas, but basically Australians and Kiwis qualify. And if you're an employer and you're not paying yourself a wage, again, read the ATO sort of fact sheet that I've put in the comments box there. You will qualify. Your second question is, my quarterly GST I had to pay, I couldn't afford to send it to the ATO. I assume you're asking what to do with that. What you need to do is talk to the ATO. The ATO is being very, very, very flexible around all sorts of payments that are owed to it. So you'll have a conversation with them if they can't pay it, and they'll say, okay, well, how can we restructure things? When will we be able to pay it? So on and so forth. And then, that'll be kind of, you'll have a conversation with them and negotiate a payment plan. And they're being very flexible with that. Next question from Noel. My wife and I own and run a motel/motel with restaurant. All our business is stopped. We don't pay ourselves a wage of any kind. How do we apply for JobKeeper? I've tried looking on every government and MyGov platforms. Again, look at the link from the ATO. You fit within that group there that we're talking about, i.e. people who run a business, aren't really an employee, aren't paying themselves a wage. So have a look. It's the ATO website you need to look at. Next question from Peter. My tenant has voluntarily closed their retail shop and refuses to pay rent or outgoings. Do I have any recourse? Okay, so Peter, what you need to work out is, firstly, does this tenant qualify for JobKeeper? Likely that they do, because they're presumably not generating any revenue through the business, or they could be trading online, I guess, but it's likely they've had a minimum 30% drop in top line turnover. Given that is the case, they qualify for JobKeeper, and then they fit within the new leasing code of conduct. And what that means is you need to give them, you need to negotiate with them, but the guidelines sort of state that you should be giving them a, you know, if we look at the total amount, the reduction in their top line revenue, let's say, you know, they're doing, they were doing 50,000, let's say 100,000 revenue a month. Now they're doing zero. All right. So what you need to do is give them a $50,000 waiver a month, so they don't have to pay $50,000 a month, and 50%, so $50,000 deferral of rent a month. Now that deferral needs to be structured in a way that fits within the code. So there's some guidance around timelines and so on and so forth. But that tenant does need to negotiate with you in good faith. If they don't do that, they're essentially in breach of the rules under the code, and they're no longer protected by the code. So what that means is you can go after them in the way that you would have been able to do pre-COVID. So, you know, what I would recommend, frankly, is you get in touch with a lawyer. We'd be happy to assist, but you need a lawyer in this situation, because you need to start looking at, okay, well, what do we have here? Do we have a bank guarantee? Do we have personal guarantees? How long is the lease? Do we have any other security? All that sort of stuff. And then there needs to be an analysis done and some attempts to negotiate under the framework of the code. And if that doesn't work out, then, you know, arguably, and we'll need to see how this plays out over the next couple of weeks, but arguably you can then take legal action in a normal way and call on a bank guarantee and so on and so forth, because they basically said, I'm not taking the protection of the code because I'm not negotiating and I'm you know, not communicating with you. So that would be the advice there. But I'd really be, you know, getting in touch with a lawyer, because it's getting to a stage with that type of, you know, dispute that you need to get that legal advice. Okay, Bishal, what if I want to get out of the lease contract? It's been around 6 months since I started the business. Now COVID-19 has affected a lot, and I'm financially down to the deep. So basically, again, getting out of a lease contract. As I've said, if you qualify for JobKeeper, you're then sort of under the leasing code, which means you negotiate a waiver and a deferral, but it doesn't mean you can get out of the lease. You know, again, getting some sort of advice, I think, is probably what you need to do now, to kind of look at the specific circumstances and work out a way forward. And again, as part of our LV Connect membership product, $200 a month, we do a lot of these sort of calls, helping people, you know, with their specific circumstances, guiding them as to how to, you know, deal with this sort of thing. So that would be the way to kind of get advice on that, I think. Okay, Gary, I've been made redundant from one role as a direct result of COVID-19 challenges. The person attached to the role was on a base. I've recently made someone redundant. I think Gary's not been made redundant. He's made someone redundant. The person attached to the role was on a base salary of 110K. With regards to the JobKeeper payment, if the person agrees, could I technically re-employ her on a new contract, probably part-time, and with a wage that matches the JobKeeper payment? This particular person would rather do this and work 2 to 3 days a week than her alternative realistic options at this stage. So yes, you can re-employ someone. That's always been super clear in terms of the JobKeeper program. The government wants people to re-employ people that they've made redundant. And yes, you can employ this employee on a different contract. My suggestion to you would be not to do it on a part-time contract, but to do it on a casual contract. It's a casual contract. It's very easy to then sort of terminate the employee in 6 months' time if you don't need the employee anymore. Part-time contract means they're accruing kind of annual leave and so on and so forth over the course of that 6 months. So re-employ them on a casual contract, but certainly you can do that. You can ask the person, you know, you can negotiate with them to work for some time, you know, for 2 or 3 days a week if you want, or you can just pass on the $3,000 without them actually doing anything. That's up to you and the employee as to how you kind of deal with that. Susan, question: my revenue has reduced by 100%, and this is likely to be the case for the period of the pandemic. Does this mean that it is reasonable I should receive a 100% rent reduction? So no. What it means is, under the code, and if you qualify under the code, which it sounds like you do, then what you get is a 50% waiver of your rent. So that's, you just don't need to pay it. And then a 50% deferral. So 50% of that rent you still owe, but don't need to pay it now you pay it at the back end of the lease. And that again depends on, there's some rules around the time, the amount of time the lease can go for, and so on and so forth. But effectively, you get a 50% waiver and a 50% deferral. So no, you can't just pay nothing, unfortunately. Well, and obviously you've got to think about this from the perspective of the landlord as well. If they're not getting any income at all, and the back end, at least if they know it's a deferral, they can count on getting some of that money back down the track. Because they've got their mortgage and whatnot to pay on the property as well. So it's important to kind of consider all sides there. Okay, next question. Are tenant outgoings provided for in the lease treated the same as rent for the purpose of the government advice on deferrals, etc.? So broadly, the concept is proportionality. So if there's outgoings that, because the property shut down or whatever, are massively reduced, then all of that cost should be passed on to all that cost savings should be passed on to the tenant. But for the purpose of the code, it comes down to rent, not outgoing. So that's sort of the nub of it there. Andrea, without a contract, can an email acceptance of a quote still be enforced at a later date if a company has had to delay / reschedule work as a result of COVID-19? This is, I guess, a legal question, which is difficult to answer without a bit more context. But in terms of a contract, there are sort of three elements to a contract: offer, acceptance, and an intention to create legal relations. All right. So in the context of an email quote, so you've quoted, that's an offer. The other side said yes, that's relations potentially, or was there something in the emails back and forth which said, okay, we'll now document this in a kind of written contract, which would indicate that potentially the email exchange was not an intention to create legal relations. So that's a difficult one. We need to look at the emails and so on and so forth. But the reality is, even if you've got an enforceable contract, if you've got a counterparty that can't pay, it's not going to help you that much. Or, so you need to start thinking about the amount that's owed, whether you can kind of renegotiate something, whether you can kind of get some money paid now and then delay the rest till later. It's important to start being pretty commercial and pragmatic, in these situations now, because, the recourse to the law straight away is probably not going to necessarily be that helpful, at least in the next kind of month or so. Things might kind of get back to a more normal situation, in kind of a month to 6 weeks, but we'll need to wait and see. All right, Tim, as a sole director that gets paid a small amount of dividends at the end of the financial year, I understand that I can apply for the JobKeeper, but do I have to make a payment of $700 per week to qualify? It doesn't seem to be explained anywhere. I understand that employees are paid $3,000 a month to qualify. Tim, yes, you need to pay yourself the amount that you're going to claim from the ATO. The basic premise of this is the ATO, or the government, are paying for employees, or anyone, for employees, sole traders, whatever, that have received $3,000 in the time period, right? So you need to be paying the money, and then you get it reimbursed. If you don't pay the money, you're not going to get it reimbursed. That's the current guidance. Okay, so yeah, make sure you pay yourself something, the amount, the $750 a week, or it's $1,500 a fortnight. So it is a bit more than $3,000 a month, yeah. So it's important to talk to your accountant about calculating the exact amount that you need to pay on a monthly basis if you're doing monthly payroll. It's worth remembering. Okay, Tracy, we have staff that are refusing to come to work. They've offered to work from home. However, we're still operating, and the nature of our business, which is childcare, requires them to come to work. Can you please advise if they're eligible for JobKeeper, or can we decide not to apply for JobKeeper payments for them as they're refusing to come to work? Okay, so you have employees who are employed to do a job, and they're refusing to do that job. Broadly, they're rescinding their contract. They're saying they're effectively resigning. So what you can do is terminate them, and then you don't pay them JobKeeper. Now, that's broadly in the context of I'd say sort of white collar workers, so on and so forth. In the context of childcare, you need to then start looking at, okay, is your workforce unionized? What's the kind of award structure? what's going on in the kind of details. Are they people who have, are they older people? Are they people with pre-existing medical conditions, so on and so forth? Are the medical reasons why, they're higher risk category and so on and so forth? So you need to start looking at the ins and outs. But broadly, if someone's saying, I'm not going to work, which, if it's like saying you work in construction and I'm not going to go to the construction site, I'm going to work from home. Well, you can't work from home because nothing will get built. So in that context, that's someone saying I'm not coming to work, which means you can terminate them. So there's a conversation that, the way I would be doing this is frankly having a conversation with the employees. It's like, look, just so we're clear, you're not going to get $3,000 a month to sit around at home. This is kind of the situation. Need you to come in. How about we kind of work this out? You have that kind of conversation, and get it all done by mutual agreement. That's going to be the best way of dealing with that kind of issue. Okay, John, I was driving Uber from June to March last year and previously 6 months in 2017-18. Am I entitled to JobKeeper? Driving for Uber, you'd be a sole trader, but that was last year. So you weren't really operating this year. I don't think so, really. I can't really see how you would qualify, unfortunately. Again, we can kind of look into it in more detail to see if there's any exemptions and so on and so forth. But from my reading of it, probably not. Okay, so another question from Tracy. I'm a sole trader who's been consulting to one single business for the past 18 months. I have no contract with them. I simply issue an invoice for services monthly. This work has been put on hold. Am I eligible for JobKeeper as an employee of my own business? Yes. Again, please just read the ATO guidance that I've put in the comments box, because that explains that you are, and explains how to go about it, how to go about claiming it. How long can an employer keep an employee stood down for until they have to pay redundancy for that employee? Well, that's interesting. So the question is, have you actually stood down the employee, or has that employee agreed to go on leave without pay? That's the first question, because a lot of people think that they stood down an employee, and they haven't really. What they've said is, can you take leave without pay? Now, if you've taken leave without pay, it's really indefinite. But on the other hand, if someone says, no, I want my redundancy payment, like you're saying that I need to take leave, you're saying you can't afford to pay me, okay, you need to make me redundant. They can if you leave without pay thing, they can say, I want a redundancy. In terms of the stand down, it depends on the industry that you're in and a whole bunch of other factors. So what we need to do there is have a chat to you and understand exactly what's going on, and whether you have stood them down, what industry you're in, what's going on in that context. There's different things going on in different industries, and then we can provide some guidance on that. Okay, next question. I'm trying to get through this as quick as I can. We've got another 10 minutes. Okay, can your landlord seek outgoings? We've talked about outgoings, so I'll keep going. If you have an employee who usually earns less than the JobKeeper amount per fortnight, can you increase their hours to match the make-up pay required so that their hourly rate stays the same while they're receiving JobKeeper? You can do that through negotiation, but you can't really require it of the employee. So if you're claiming JobKeeper for an employee, you need to be transferring them $3,000 or $1,500 a fortnight. Okay, so almost a bit over $3,000 a month. So the employee can kind of say, I don't want to do more hours, and then it's kind of a conversation around, okay, well, one level you could say, okay, I'm going to fire you if you don't do more hours. Is that really the intention? Probably not. Is that the way you want to do things with your employees? Probably not. So, it's a bit of a grey area. Again, the best way of dealing with this sort of thing is having a conversation, having a discussion with the employee, and just kind of seeing if you can get, come to some kind of agreement. Okay, so look, Stacey's Stacey's had a question. I'll do two questions. I'll just do one of them. I've had two long-term casuals. One of them has another job. I could not afford to pay them both JobKeeper. Okay, so the first thing is that you're not paying a JobKeeper. The government's paying the JobKeeper, right? So the government, you pay them their monthly wage, and the government reimburses you up to $3,000. So unless there's a cash flow issue, it's not a question of you can't afford to pay anyone JobKeeper, because you're not. The government's paying the JobKeeper. But anyway, I discussed with the one who has two jobs, and she was happy to nominate her other job so she can receive JobKeeper. Also, her role doesn't exist because she is retail and we're closed at the moment. Okay. The other casual can still bring work in working online. Okay. So casual that has two jobs. So the question is a bit it's hard to read, but she has been with me for nearly 15 years and works 10 hours a week. Do I have to stand her down and pay her long service leave, or can I just leave her on the books without it affecting both JobKeeper for the other employee and myself till we have work for her to do? Okay, so look, if they're a casual, I'm not 100%. So casuals don't get long service leave. So look, there's a whole bunch of stuff in this question. I think the question, the best answer will be to get in touch, so we can go through the specific details of of this particular question. But my overall guidance on this kind of point is, you're not paying anyone JobKeeper. The government is paying them JobKeeper. You need to pay them their salary or whatever in the month prior to you getting the JobKeeper, but the government's reimbursing you up to $3,000 per employee. That's how it works. So the cost, like for a lot of businesses, if you've got an employer who's only earning around $3,000 or less a month, you're basically getting a free employee for 6 months. So it can actually work very well for a lot of businesses. Okay, let's go, Susan. If I have to cease trading due to being a sole immunocompromised dentist, can my landlord sue me for damages? Okay, so, well, there's a bunch of things here. So realistically, what we're saying here is you're a dentist, you've got a tenancy, and what's happened is you stopped trading. So you should fall within JobKeeper and therefore under the code of conduct, and your landlord will need to give you a 50% waiver on your rent and a 50% deferral. So that's kind of how it should work, and so you qualify under that leasing code, and that's what you should be using going forward to negotiate with your landlord. Okay, another question from Vikul: how does JobKeeper work for tech startups like ours who started operations in January 2019? So I have no relevant data to show for last year, but the COVID-19 situation has meant a significant decrease in business from January to March itself, and also future IT projects being cancelled. So you have been in business for over a year, but regardless, the ATO has discretion to basically go, all right, you're a fast growth startup, your revenue's kind of gone like this and then like that. So you're still doing more revenue than we were this time last year, but on the other hand, there's obviously a big decrease in revenue from the beginning of the year. So the ATO will have discretion. The guidance isn't out yet, but it's likely that a business like yours will qualify for JobKeeper. We just don't know for certain yet, but that is the intention of the ATO. Okay, next question from Kate. Once you substantiate eligibility for JobKeeper, do you have to continue to demonstrate relevantly the 15, 30%, 50% decline in turnover for each month you are claiming the payment? Okay, currently, no, you don't. If you show that you had the March on March, or you're going to have the quarter on quarter decrease, you do not have to show continuing 30% the decline in revenue. Okay, so you just got to show it once, and that's it. Next question, Christy. We'll do this one. Our accounting is done on an accruals basis, but our BAS is done on a cash basis, based on normal revenue, cash and orders. We qualify for JobKeeper, but revenue shown via BAS means we don't. can we still qualify? So if your business activity statement's done on a cash basis, that's what should be used. So based on yeah. So it's got to be done based on how you're accounting, or it's done based on how you're submitting your business activity statements. If you submit your business activity statements on a cash basis, if you're accounting on a cash basis for BAS, then the decrease needs to be on a cash basis, as shown in your business activity statement. If you're accounting using accruals accounting for BAS, then it's on accruals. All right. So if you don't qualify on a cash basis for March to March, then you can say, look, I anticipate qualifying for the next quarter, April, May, June, or just for April, or whatever it might be. Depending on your business, frankly, it shouldn't be too hard to, put yourself in a position, where you qualify somehow. Again, you've got to be, you can't do things that are designed to ensure you qualify, but, again, it shouldn't be that difficult to do this. Talk to your accountant would be my advice. Leanne, if your business is in suspension, nil income, what do you offer in deferral? Again, I think this is probably talking about leases. So if your business is in suspension and generating no revenue, you get a 50% waiver and a 50% deferral. That's how it's structured under the leasing code. What are retail travel agents? And usually we are retail travel agents and usually log GST credits sufficient to offset our own employees' PAYG. Will that affect our qualification for JobKeeper? Okay, this is straying into accounting land. So the rules are for JobKeeper, it's all based on your GST revenue as submitted in your business activity statement. Okay, so if you've had a 30% decrease from March 19 to March 20, or you're going to have the Q4 to Q4 19 to Q4 20, or April 19 to April 20, and you got a 30% decrease, you qualify. You've got to look at your business activity statements and GST revenue in those business activity statements. So that is only Australian sourced revenue, not foreign sourced revenue. Okay, Heidi, can you reduce hours and direct the employee to take annual leave so it equals 15 grand per fortnight? So, well, it depends obviously on the employee's employment contract. If they're a casual employee, then yeah, you can reduce their hours, but then they wouldn't have annual leave, right? So it sounds to me like you've got maybe a full-time or a part-time employee, and basically you can do anything as long as that employee agrees to it, right? So if you can do anything by mutual agreement, and you document that in a variation letter. If you want to do something unilaterally, then you need to start. The various rules have come out around what the government's saying you can do unilaterally. My advice on all of these webinars has been: try not to do things unilaterally. Try and have a conversation with your employee, with your team. People aren't looking to screw over their employer in this environment. People understand the need for a business to survive. And, if it's reducing hours and they're still getting their 15 grand a fortnight, that could be something that works quite well for people. So I'll be having a conversation and do whatever you want to do by mutual agreement wherever possible. So yeah, you can do anything you want by mutual agreement. Question from Kate: can you please clarify on what basis the code does not apply to license agreements, thinking that these may be captured if they are a commercial tenancy in nature, or an agreement entered into by of commercial premises? Good question, Kate. Our reading on it, and this is based on our leasing team's reading of it, is that licenses are not captured. I agree with you. In an agreement entered into by an operator of commercial premises, potentially, but something like a WeWork could say we're not an operator of commercial premises. We're a tenant of commercial premises. Our business isn't operating commercial premises. It's running a co-working space. And so what's going to happen, I think, is firstly the code has come out, right? But then each state needs to legislate the code. So what we might see is each state kind of getting more into the details of this and going, okay, well, co-working spaces that are using licenses, what's the deal here? Let's legislate that specific question, that specific issue. So it could come out to be different in different states. And then the second thing we're going to see is there's compulsory mediation as part of the code, and we might see some of these questions going to mediation. But right now, our overall view is that a license agreement doesn't qualify. Okay, so it's 2:46. We were supposed to finish at 2:45. I'm happy to keep going through all the questions. So I'll keep running through them, and obviously if people have time to stay, that's great. Okay, next question. I'm a small business owner and an employee of a business, currently waiting for permanent residency. As I was on an 820 visa, partner family visa, am I eligible for JobKeeper? Okay, so I'm not sure about that one. What we'll do, Renan, just get in touch to us at LegalVision. Just give us a call. If you want to write to me personally, lachlan@legalvision.com.au. I'll check in with one of our immigration lawyers and just get you an answer on that. Off the top of my head, I don't know, but we can answer that in 2 seconds. So just email me, lachlan@legalvision.com.au. Next question from Yami. Employee would like to take no pay leave and doesn't want to work during this period. Does the employer need to apply JobKeeper payments to these employees? Yes. Let's be clear. You need to pass on every cent that you get in JobKeeper. Okay. And by pass on, I mean, if you're paying someone, more than $3,000, then, you're effectively passing it on, because they're making $5,000, you're paying them $5,000 a month, then the $3,000 that comes from the government, you just keep. If they're earning zero because they're on leave without pay, you need to pass on the whole $3,000 to them. If they're earning $1,500 a month because they're working a few hours or whatever, you need to top them up with an extra $1,500. So effectively, the business is $1,500 better off, not $3,000 better off. You can't. The JobKeeper payment isn't yours to keep. It's designed to make sure that you're keeping an employee on the books. And so every employee that you have, that you've applied JobKeeper for, needs to be getting that $3,000 a month, or it's $1,500 a fortnight, which is a bit more than $3,000 a month. Be very clear on that. Okay, Amber, what happens if you're not on a lease and paying month to month? Could the 50-50 split waiver and deferral still apply? And are you possibly open to more negotiation? Well, you're in a great position, Amber, if you're on a month to month lease right now. And frankly, depending on the type of business you're in, I'd be considering getting out of the lease if you're not operating. But if you are operating, then yes, you will qualify if you've had that 30% drop, but you won't qualify for the deferral, because the timing structure of the deferral, of the code basically means that you won't qualify for deferral, but you will qualify for the waiver. So you could potentially get the 50% waiver if you're on a month to month, and that would be great, right? Igor, I'm a property investor deriving rental as income between my wife's and mine's properties. Okay, this question's too specific for this forum. So, Igor, what we can do is, just get in touch again, lachlan@legalvision.com.au, and I'll see if we can assist and get you an answer to your question, because it's quite specific. Bruce, is the 1st of March date for being in business critical? My ABN number was issued on the following Monday, the 4th of March. Okay, so the question isn't when you had an ABN. When did you start trading? Okay, when did you start trading? That would be the question, because you could have started trading beforehand. I think if you were trading beforehand without an ABN, you could still be okay. Again, the challenge for you is going to be, showing that you've had a dip in revenue. Like if you were trading beforehand, well, fine. But if you kind of really just started trading around the beginning of March, then it's hard for you to say, COVID-19 affected my business, or to prove it, right? So, I suspect that could be a bit of an issue, and you may not be eligible for JobKeeper based on that. Okay, so look, before we go, I just wanted to mention again, we're assisting lots and lots of clients with our LV Connect membership, $200 a month. Basically what you can do is, book in with a call with any of our lawyers, unlimited number of calls, about unlimited number of legal issues. Obviously, you get heavily discounted prices on our 4 fixed fee prices. So we're assisting lots of businesses with this right now. I really encourage each of you to consider LV Connect membership as an option. What we're doing is a special sort of offer to anyone who's been on this webinar. If you email Anthony at legalvision.com.au, who's our marketing director, we've got a special offer which will hopefully be quite enticing. I'm not going to let you all know what it is. Just email him, and it'll be a discount on LV Connect membership. So if you're interested, get in touch with Anthony and Anthony at legalvision.com.au, and we'll be able to assist you with that. And we'll be basically running another one of webinars on Thursday. We're going to focus again on Thursday on just sort of the day-to-day questions. And then next week, we're running a webinar with Carl Hutchins, who's a leasing expert. So he assists sort of tenants on tenant negotiation, and is obviously very actively involved in helping tenants kind of negotiate, big leases, renegotiate big leases right now. So we'll be emailing the database about that, inviting you to that webinar. That should be a really good session next Thursday. So thanks a lot for attending. If you have additional questions, please email them through, because we'll answer them all on Thursday. And look, everyone just stay safe and stay in business. Thanks a lot. Cheers.